So today we're talking about AI and data protection. So moving on to the next slide. There are three speakers today, myself and my colleagues Charlotte and Hannah, all of us from Astrid's data protection team. If any of you have been on these webinars before, you'll probably recognise all three of us. Next slide, please. So what we're going to be talking about today is AI and data protection. We're going to do a bit of an introduction on AI generally. I talk about data protection compliance when using AI, and also look at some issues from the privacy regulator, and hopefully make some practical recommendations which will help you. So moving on to the next slide. What actually is AI? I did some Googling on the internet to try to get a good definition of this, because it's a term that's used or thrown around all the time at the moment, being such a hot topic. And I thought this one was quite a good one. Artificial intelligence is AI programs that use data collected from different interactions to improve the way they mimic humans in order to perform tasks such as learning, planning, knowledge representation, perception, and problem solving. So it's not really intelligence at all. It's a mimicking of something that humans do, but which is based on data that's collected. It's a hot topic at the moment, and many pioneers of AI have been saying things like they wish they'd never started, which has caused quite a lot of concern generally in the press. But why is AI an issue for data protection? Well, going back to absolute basics, those are the four things that data protection seeks to regulate: how data is collected, how that data can be used, how it can't be used, and how long you can keep it. So how do those four principles interact with data protection? Well, if we go on to the next slide, we can have a look at UK GDPR Article 22 and what it says about it. And Article 22 says that the data subject shall have the right not to be subject to a decision based on automated processing which produces legal effects concerning him or her, or similarly significantly affects him or her. And the only basis on which you can do that is if it's necessary for entering into a contract between the data subject and the data controller, or is based on the data subject's explicit consent. And even if those two requirements are met, the data controller must implement suitable measures to safeguard the data subject's rights and freedoms and legitimate interests. And that must at least include the right to obtain human intervention so that the data subject can express his or her point of view and contest the decision. So that's, in summary, why data protection and AI are closely interrelated. Then, if we go on to the next slide, there are some additional requirements if special category data is involved. And you'll remember from previous webinars that special category data is data about race, ethnic origin, religious or philosophical beliefs, and those various other types of data on the slide. Now, if we're talking about special category data, decisions must not be AI-based unless the data subject's explicit consent has been obtained or there is a substantial public interest. The second one of those is going to be very difficult to achieve in any normal context other than possibly a government exercise. In addition, suitable measures to safeguard the data subject's rights and freedoms and legitimate interests must be in place. So having gone through that general introduction, I'll now allow you to listen to Charlotte, who will explore some of those issues in more detail.
Thanks, Tom. So data protection and data processing compliance when using AI, and this is an interesting topic, as Tom mentioned, it's something that is being widely publicised in the press at the moment. Next slide, please. So currently there's no AI specific privacy regime within the UK. There's actually no legislative framework for AI at the moment. The governance of processing personal data using AI falls under the existing data protection regime. So businesses do need to apply existing data protection obligations and principles to AI-based data processing. And as I'm sure you've seen, there's a lot of government consultation on this area, which is ongoing, not just in the context of AI with data protection, but in the wider AI framework. And the government is looking to legislate this area and put together some legislation in relation to how we use AI going forwards. It's released a statement saying that it wants to implement a proportionate, future-proof and pro-innovation framework for regulating AI. And they do have a white paper in circulation at the moment, and the consultation for that does actually close tomorrow if you are interested in this area. So we do expect some legislative framework to be put in place, but the timeline for this is currently unknown. So this should be an area that if you're looking to use AI tools as part of your business practices, do stay up to date, because this will govern what you can or can't do with AI tools going forwards. Next slide, please. So the relevant data protection principles. So hopefully everyone's aware of the sort of general overarching data protection principles that underpin any processing of personal data by organisations. I've picked a few here. These aren't all of the principles, but these are the key ones that we think are particularly relevant when considering AI. So firstly, being the lawful basis. So what is your lawful basis? As I'm sure you're aware, there are 6: consent, legitimate interest, contract, legal obligation, public task, and vital interest. You must ensure that you have established this before you undertake any processing of personal data, and there's no difference here when you're using AI tools to do that. Secondly, what is your status? So are you a controller, joint controller, or processor? So if you're using and developing, if you're developing AI using personal data, you will most likely be a data controller, as you will be exercising judgment and control over that personal data through the use of those AI tools. By its nature, in terms of developing and enhancing that data, that's why often you would be a controller in those circumstances. But if you are using or adapting models developed by others, it's not clear cut, and you may well be a processor, but you do need to undertake that determination exercise to assess whether or not you would be a controller, joint controller, or processor. Data protection impact assessments, DPIAs. So you must assess and mitigate any data protection risks using a DPIA before you start using AI to process personal data. So as a general rule, DPIAs are required where you're processing personal data is likely to result in high risks to those individuals whose data you're processing. The ICO guidance does provide some helpful content around this area and says that you must carry out a DPIA if you're using systemic and extensive profiling or automated decision making to make significant decisions about data subjects, if you're using innovative technology in combination with some of the other criteria in the European guidelines, if you're using profiling, automated decision making, or special category data to help make decisions about somebody accessing either your service, a particular opportunity, or a benefit. Carrying out large-scale profiling of individuals, combining, matching, and comparing data from multiple sources, or tracking individuals online or offline in terms of their location or their certain behaviours, and again, in combination with other criteria. So taking into account that guidance, it would be very unlikely that you wouldn't need to do a DPIA if you're using AI. It would fall under one of those categories, and you do need to be considering that when you are thinking about undertaking and implementing AI processes as part of your business. Transparency, again, another one that's very familiar, I'm sure, to most people. You must make information about the processing publicly available unless you have an exemption that applies to your business. And the general rule is that you must communicate information about your processing activities directly to the data subjects when you are collecting that personal data. This is usually done through a privacy notice, which Hannah will discuss in more detail later on in the webinar. Unnecessary processing, and this is an interesting point when considering AI. So data protection law requires that you do not process personal data that is unnecessary to the purposes for which you collected it. And the information should be relevant and limited to what is required. So by the nature of AI, it learns from the data that is provided, and it can and has the ability to develop new data sets about individuals that wasn't necessarily collected at the time that their initial data set was taken and processed. This is something that businesses need to be alive to, because it may be that you could inadvertently start creating and processing additional data about individuals that goes beyond what is required. So it comes down to really understanding what are those AI tools that you are using and what are the processes and systems that sit behind those. How will information be gathered? How will data be generated by that tool? What is the purpose of it? And this should go back as well to, thinking about your lawful basis and those other key principles around why you're collecting that information and what you are doing with it. Complying with individual rights requests, again, something I'm sure everyone's familiar with, but data subject rights, they have the right to access personal data, they have the right to rectify their personal data, and in certain circumstances request deletion of their personal data. So in thinking about AI tools, are you able to access all of the data that is being stored and created by that AI model? And can this be truly deleted if the AI tool continues to learn from the data that was inputted into that model? And that is a fairly open question at the moment. It is very specific to the AI tools that you'll be using, but it's something that you should be exploring as a business and thinking more deeply into. This is one of the areas that we would say, do a deep dive into what those systems look like, particularly even if you're, outsourcing to a third party and you're procuring services from a supplier that's providing AI services to you, you do need to be asking these questions and make sure that you're undertaking that due diligence. Thinking about this from a compliance perspective is really important, and it does feed into those wider business conversations as well. So if the use of the AI tools requires certain data and the data subjects have the ability to request that is deleted, how does that affect the AI model? Could the system become biased? Could there be a circumstance where a particular group of individuals requested and had their deletion rights enacted that meant that that model didn't have a sufficient amount of data to then create unbiased results and outputs? So again, it's thinking about this in the context of those AI tools and what they're doing. Next slide, please. So managing and mitigating security risks. This is, again, a really hot topic at the moment, as I'm sure you're aware. Everybody is familiar with your sort of more traditional data breach risk, i.e. data leaks, hacking, etc. And organisations processing personal data will be already aware of those risks, and we would hope have certain measures in place to protect against them. AI does go one step further because there are specific risks related to AI and personal data breaches that you do need to be thinking about. And these are very complicated. So we don't have time to do a deep dive into this today, but we're going to give you some sort of general overview of some of the risks here. If you are using AI tools, you should be aware of things like data poisoning, evasion attacks, model extraction attacks, and the impacts that these can have. So this can cause things like biased systems, or for example, biased outputs in terms of your AI modeling, attacks to purposely cause the AI model to make mistakes in its output, and then of course the more sort of familiar territory of breach of confidential or sensitive information, and of course leaks of personal data. So it is something that you need to think about. There are different types of security risks when it comes to AI. There's concepts such as white box attacks and black box attacks. White box attacks being where an attacker has access to the AI model itself, including the architecture of the AI system and its parameters. With black box attacks being where an attacker has no access to the actual model, but can observe the outputs from that AI model. And that's obviously a very basic way of describing it, but on a very high level. But it can involve an attacker manipulating the data that's used as part of the training of the model, and in certain cases, extracting data that it was trained on in order to then steal that AI model. So there's lots of different aspects here. It is an area that we would say, if it's not something that your business can deal with in-house, do seek specialist advice on this, and make sure that you are identifying these risks, documenting them in your data protection impact assessment, and mitigating them as far as possible, and making sure that you have appropriate security measures in place to try and combat these risks. Next slide, please. So Tom has already touched on the UK GDPR Article 22 requirements. There are specific provisions dealing with automated decision making, this being decisions that are made by automated means without human involvement, and also what we call profiling. So this is an automated processing of personal data to evaluate certain things about an individual. They are distinct, but they can form one and the same. This is important when it comes to AI, as often AI will fall under Article 22, particularly automated decision making, but they are distinct. So AI systems perform certain tasks and have the ability to learn from that task. And Tom talked about a level of sort of human intelligence there, which is what makes AI so innovative. Whereas automated systems are designed to perform repetitive or routine tasks that don't normally require that intelligent aspect. They are more based on predetermined algorithms or processes. But AI tools may use automated decision makings as part of that system. So it is important that, again, you do that deep dive into the systems that you're using so that you can understand whether or not your processes and your processing of personal data falls under this Article 22. The ICO gives some helpful examples around automated decision making, including things such as an online decision to award a loan or a recruitment aptitude test, which uses pre-programmed algorithms and criteria to do test scoring, etc. And profiling is any form of automated processing of personal data consisting of the use of that personal data to evaluate certain personal aspects relating to a natural person, in particular to analyse or predict aspects concerning their performance, whether that's at work, financially, health, etc. And as Tom mentioned, you can only carry out these types of processing where the decision is necessary for entry into a contract, it's authorised by domestic law, or it's based on express consent. The GDPR does go one step further as well to say that you do have to implement those safeguards that Tom talked about, and it requires you to give individuals specific information about this type of processing, which is above and beyond your sort of standard privacy notice wording that you would normally expect to see. It obliges you to take steps to prevent errors, to prevent bias and discrimination, and it gives individuals the right to challenge and request a review of that decision, including having human involvement. So you do need to make sure that, you really understand the processes that you're looking to use and that you have the right mechanisms in place for individuals to challenge some of these automated decision-making processes and some of the tools and processes you're using, and that they can express their point of view and explain an explanation as to how a decision was reached about them. Again, this is underpinned, and we can't stress this enough really, that you need to understand how your systems are operating, even if you're not a tech business. If you are looking to use these tools, and I suspect it's going to become more common in the very foreseeable future, this is becoming readily available, and AI is something that is, bringing a huge amount of innovation to business, but it is an area that you do need to think about very carefully and ensure that you have appropriate safeguards in place. So I'm going to hand over to Hannah, who's going to discuss some of the practical aspects of the things that you can do to help meet your compliance obligations in this area.
Thank you, Charlotte. So AI is obviously a really fast-moving area at the moment, and with that comes significant privacy risks, which is why we've got it's really high on the agenda for privacy regulators at the moment, and it is subject to a lot of scrutiny in the privacy regulator space. So if we move on to my first slide, a nice example of this for us to explore in detail is the Italian Data Protection Authority, the Garante's temporary ban on ChatGPT for users within Italy earlier this year. Now, that decision, or the ban that was imposed, is a really helpful illustration of the privacy issues with generative AI tools such as ChatGPT. Now, ChatGPT is a form of generative AI, and that is going to be the focus of my section. So generative AI is a type of AI which creates content. So that could be images, it could be text, it could be audio, and it produces that as an output in response to your input data that you're feeding to the model. So you'll send it an instruction and it will then process or generate some sort of content in response to that instruction. And as a result, it can be a really useful tool for businesses. And if people use generative AI responsibly, this is something that they can do they can, it can be a huge efficiency or have huge efficiency benefits for businesses, but that is very much with the kind of emphasis on using it responsibly. And that's something that businesses are really trying to grapple with at the moment. So earlier this year, on 31st of March, the Italian Data Protection Authority, the Garante, issued a temporary ban on OpenAI's ChatGPT. Now, it did this for a number of reasons. It had a number of key concerns with OpenAI's ChatGPT, and I'm going to quickly walk you through what those concerns are, because I think they're useful to illustrate, what the real issues are with generative AI. So, firstly, it was concerned that OpenAI had processed vast quantities of personal data for the purpose of training its AI model without any lawful basis. And that's because, as Charlotte touched upon earlier, to be able to train an AI model, it needs to have access to vast quantities of data. The more data it has access to, the more informed the model is going to be. And that meant that OpenAI had to use vast volumes of data, a lot of which was publicly available, but a lot of that did contain personal data. And so then looking at what lawful basis they had for that processing activity, it's really difficult to point to what that was. So for the legitimate interest lawful basis, really hard to show that they were able to strike the balance between their legitimate interest on one hand in training the AI model, but also the protection of the privacy rights of the individuals on the other. Then looking to consent, again, just because of the vast volume of data that we're talking about here, it wasn't feasible for them to go and get consent from all of these data subjects whose data was used to train this AI model. So real concern there, number one, was lack of lawful basis for that training exercise at the outset. Second key concern was around insufficient information being provided to data subjects. And that really just boils down to that privacy policy that they were making available just did not go far enough. It didn't provide clear information to data subjects about how their information would be used by ChatGPT. Third concern then was around age verification. Now, because there was no age verification mechanism on the tool, children could access ChatGPT and they would be able to see output, see content generated, which hadn't been tailored for them, and it just wasn't appropriate for their age or their awareness. So there was no sort of safety mechanism for children on the platform. And the final key concern that's worth us noting here is accuracy. And that's because there's no guarantee around the accuracy of the output that's produced by the AI. So this means that the AI results could be misleading and they could have incorrect information about a data subject, which obviously could be quite damaging. So the Italian Data Protection Authority obviously was so concerned about these things that it prevented OpenAI from making ChatGPT available within Italy. But just a month later, it then lifted this ban. And so why was that? Now, a big part of the Italian DPA's decision to lift the ban was because OpenAI was really cooperative and it directly addressed the vast majority of the concerns that the Italian DPA had raised. Now, just to quickly walk you through what action it took, it confirmed that users of ChatGPT could complete an online form to opt out of their information being used by the AI model for training purposes. It also improved its privacy policy, so really added in extra information to ensure it was meeting that transparency requirement. Also, when it switched back on in Italy for Italian users, it provided a welcome pop-up, so welcome back. And as part of that, it had an age verification mechanism. So it asked users to verify that they were either over the age of 18, or if not over the age of 18, that they were between the ages of 13 and 18 and had parental consent to use the tool. And finally, they also enabled data subjects to request deletion of any information they considered to be inaccurate. So key takeaways there are, this shows really good dialogue between OpenAI as that AI tool provider and the Italian regulator. And that enabled OpenAI to rectify the issues that the Italian regulator was raising. So moving on to my next slide, what is the position that other privacy regulators have taken? Now, we've seen that the rectification measures OpenAI have implemented go some way to resolve concerns, which is great, but there are still really fundamental privacy concerns with generative AI. And the key one being that even if data subjects can now opt out of their own personal data being used via an online form, opting out, that only helps for the processing of data of users once they're onto the ChatGPT model, and that sort of future looking processing. It doesn't in any way speak to or address the issue around that AI model having learned all of its sort of processing activities and learning all of its intelligence from vast quantities of personal data at the very outset, which was collected unlawfully. So that is sort of the fundamental concern that still hasn't been resolved. And although other privacy regulators stopped short of issuing a ban on ChatGPT, they did request further information from OpenAI. And so that's to help inform any future action they might want to take. And also the European Data Protection Board, which is the EDPB, they've set up a task force, and that is to coordinate action across those European privacy regulators in respect of ChatGPT. Interestingly, we haven't heard much yet from that task force, but I expect we will do in the near future. And I don't think that the Italian DPA's ban it will be the last we'll hear about ChatGPT's privacy compliance. So definitely watch this space. Um, then looking closer to home at the UK Information Commissioner's Office, they are very much staying they're very much staying alive to what is happening within the EU. So they themselves haven't issued a ban on ChatGPT, but because of the noise that's happening within the EU and the concern of these EU privacy regulators, I think this probably was part of the timing, but the ICO then shortly after issued a blog post on responsible use of generative AI tools. And that blog post actually summarizes a lot of what Charlotte spoke about in her section, which is how do you use AI in a way that complies with current data protection legislation, and looking at those key data protection principles and how you apply those to AI. So that is a really helpful resource, and that's available on the ICO's website. And although the ICO as a regulator is very keen to facilitate innovation, and it is very much taking a pro-innovation approach at the moment, they've made it clear that they won't shy away from asking questions of people that are using AI or developing AI if they think that they're not doing so in a way that complies with the law, or they're not doing so in a way that considers the individual privacy rights of data subjects. So that is the current status of opinion amongst privacy regulators, so very high on their agenda at the moment. And finally, on my last slide, I just wanted to leave everyone with a few practical recommendations when using generative AI tools, because it's something that we are receiving a lot of questions about at the moment. So first of all, due diligence. And this is just about looking into the background of your provider. So looking at whether there's any public criticism of them, there's any issues with the tool, what security measures do they implement, what contract provisions do they have, and really making an informed decision about which tool you're going to use. Secondly, then, controller or processor determination. Now, as Charlotte mentioned at the start, this is not clear cut, and it's going to be very situation specific. So you'll have to make a decision about the status of the tool you're using, depending on their processing activities. But it's important to determine whether your chosen AI tool provider is going to be a controller or a processor. And that's so that you can then put in place the correct contract provisions with them. So whether that be a data sharing agreement or data sharing provisions if they're a controller, or data processing provisions or a DPA where they're a processor. Quick example using OpenAI on that one. OpenAI make ChatGPT and also another tool, DALL-E, available as their consumer services. And for those consumer services, they are a controller. Now, for their business API services, they are positioned as a processor on behalf of their customers, with their customer acting as a controller. So when you're appointing OpenAI and using their business API tools, because they would be your processor, you then need to enter into a DPA with them. And they make their DPA available online via their sort of online terms page. And there's a click through there where you can execute OpenAI's DPA. So that's a really important one to keep in mind. Thirdly, then, robust internal rules and procedures. So if you make the decision that you're comfortable with OpenAI style generative AI tools being used within your business, you then need to implement rules around what your personnel can and can't do with these tools. So what tasks are you happy for them to complete? What tasks do you definitely not want them completing using AI tools? And also, really importantly, what data are you happy for them to put into that tool? Now, we're actually seeing a lot of organizations taking a really cautious approach. And because a lot of the issues around not fully understanding what's happening to data once it goes into the AI model, concerns around not being able to request deletion of that data if needed to once it's been fed to the model, that means that businesses are saying, well, actually, we're not happy with our confidential information, or maybe our customers' confidential information being input into this AI tool. And also personal data. They might be putting sort of blanket bans on any personal data being input into the tool. And that's even publicly available personal data. So, names of directors and shareholders available from Companies House. If you've got a blanket ban or no personal data going into the AI tool, that will include all of that publicly available personal data as well. And then finally, security accreditations, just a really quick one to touch upon, because a lot of security accreditations that people will either have or be working towards will have rules around using tools which are in beta version. And a lot of AI tools at the moment are still in beta version. So being careful that you're not selecting a beta version tool, which would then put you in breach of your security accreditations. So that has been a very quick whistle-stop tour of data protection compliance. There are much wider considerations as well when we're looking at AI, so ethical use of AI, intellectual property concerns and issues. So it's a really developing area, and it's important to have all of these things in mind. But hopefully that's been helpful to give you a flavour of some of the key data protection issues. Thank you very much for joining us, and hopefully we will see you again later in the year for one of our later sessions. I can also see that we've got a hand up potentially for a question. Conscious that we are already over time, so if you wanted to send that through via email or by message, we'll be able to answer that one for you. Thank you very much.